competition remedies is where, you know, enforcement meets reality, by which we mean that remedies really are only worth it if they have impact. So you know from theory, from law, and from case law that the aim of remedies is corrective, to correct a competition harm, restorative, which is about restoring competition, and it can include neutralizing retroactively anti-competitive effects. Preventive, you don't want the violation to arise in the future, and in some cases injunctive. More on this later. I'm not going to say what the panelists will analyze. So we decided with this distinguished panel to take you on a little journey from theory to practice, from principles to implementation. Here with me we have, in this order, Damien Gerard, the Prosecutor General of the Belgian Competition Authority, also a professor of EU law at Louvain and in Bruges. Małgorzata Kozak, I hope I pronounced it correctly, Assistant Professor of Competition Law in Utrecht and Warsaw, and Julia Tarver-Wood, Senior Litigation Counsel at the US Department of Justice at the Antitrust Division. So we'll start, as announced, it's a journey from principles to practice. Let's start with the principle. Let's start with what's in the design of a remedy. If it were a recipe, what are the ingredients? I'll start with Professor Kozak. So we know, for example, in EU law, there are principles around remedy design, effectiveness, proportionality, and what we call remedial link, relevance. We know, because we've researched it and we've written about it, that effectiveness also includes application, implementability. So the remedy needs to be implementable. It also includes enforceability. So if you don't comply with the remedy, essentially there should be a sanction. Can you tell us a little bit about the mix? What makes a remedy a remedy?
Thank you very much, Despina, and thank you very much, OECD, for having me today. So if we start with our recipe for remedies, you know, a good recipe includes first an introduction or a description of a dish, the list of ingredients, preparation and timing, instructions, and serving. So let's go with this order. So a description of a dish. I mean, I'm sure I don't need to go too detailed to this audience what structural, behavioral, and intermediate remedies are. Just a very brief outline. Structural remedies involve a very clean break through the divestiture of assets or business to a new owner, and they are the most applicable when the behavior is linked with the structure of the undertaking. The main advantage of those is when, of course, it's easy to get to the roots of this behavior. However, they are also problematic from the perspective of proportionality. I will be discussing a bit later. They also do not require a very resourceful monitoring mechanism. On the other hand, they also, the major challenge with structural remedies is to find a proper buyer. So there must be a suitable buyer who's independent and unconnected to the infringing undertaking. This buyer needs to possess the financial resources, but also to have technical expertise and incentives to develop the business into a strong competitor. And finally, this transaction, so the new buyer stepping into the shoes of an infringing undertaking, does not create any new competition concerns by acquiring the assets. Then, so this is like the most intrusive way to intervene, by asking the company, or imposing rather on a company, to divest part of the assets. Then we have, of course, behavioral remedies, which impose specific obligations on a firm's future conduct. So this could be price caps, terminating exclusivity clauses, providing access to technical information. We just heard in a previous panel how interoperability and also changing specific standards is a challenge in a highly technological businesses. though behavioral remedies could not alter the firm's underlying incentives to misbehave. And then the third category, which could be called an intermediate category, so behavioral remedies with structural elements, so some directly enforceable access to infrastructure, for instance, airport landing slots or network capacity. So this was a description of a dish, and now let's get to ingredients list and utensils. As academics, we very often try to find a normative framework to analyze specific legal institutions. And in terms of enforcement practice, I think a very suitable one is the one that discusses two sides or a balance between two sides of enforcement, which is on the one side instrumentality of proceedings and on the other safeguarding of the rights of the parties. If you are interested, Eva Lachnit wrote her PhD where she used this theory. And then instrumentality of proceedings is evaluated through such criteria of effectiveness, efficiency, flexibility, and of course safeguarding of the rights through, among others, proportionality, but also rights of defense and the fair trial. And as I said, the enforcement is a balance between those two. So if too much emphasis is put on effectiveness, then the rights of undertakings are undermined, and also the other way around. If the rights, if the latter are too much or too strongly present in the proceedings, the investigation will not be efficient. So against this background, I would like to discuss the following elements which are rooted in the instrumentality and safeguarding of the rights of the parties. And this will be also, you could say that these are preparation, instructions, timing, and serving. So I would talk about objectives of the proceedings, effectiveness of remedies, their proportionality, and their implementation. So starting with objectives, the key element is always a definition of objectives, as those should guide a design of remedies. So is it to correct harm to competition? As Despina said, those could be injunctive, corrective, preventive, and restorative, as it stands from the excellent OECD study from 2025. So generally speaking, the objective is to restore competition to the trajectory it would have not taken absent the infringement. This goal does rarely include compensation for the victims. It's more for private enforcement. So to some extent, it's present in consumer cases. What should be those objectives, or how should they be designed? So first of all, there must be a well-identified harm that is being targeted by the proceedings. We also heard in the previous panel how complex AI ecosystems and also underlying network effects are. So this is this step where actually competition authorities should also define what is the issue there and to what extent this issue is going to be addressed through potential remedies. Moreover, as remedies are often proposed by the parties, it must be very clear what sort of harm is being addressed and in what way. Then we are turning to effectiveness. So once we define the objectives, the effectiveness in this respect will be the fulfillment of authorities' objectives. So promotion of compliance, but also to some extent of deterrence. And so the remedies should have an ability to stop the behavior, prevent its repetition, and re-establish competition. What is important in respect to effectiveness? Of course, these are timing considerations. The more dynamic the markets are, the sooner the reaction needs to be, and because it is possible that there will be tipping of markets, for instance, by a dominant company. Also, OECD studies from 2025 advocates for more cooperative remedies, especially in cross-border cases. So the need for cooperation between different competition authorities helps avoid conflict. This cooperation helps avoid conflicting remedies that might otherwise force firms to abandon pro-competitive transactions or have contradictory results. I said instrumentality is the one is one side. The other is, of course, safeguarding of the right of the parties. So proportionality, as also Despina mentioned at the beginning. Those must, so in this respect, remedies must correspond to the nature and scope of the identified harm and must be necessary to correct it. The option that is chosen should be the least burdensome for the parties as possible. And here, this is especially problematic in the case of structural remedies, because this is a one clean shot and nothing is more. And then, last but not least, we serve the dish. So the extremely important stage of this whole process, which is implementation of remedies. And this is, of course, part of effectiveness under OECD report. So in this stage, the questions that are vital to be answered, this is how remedies are going to be executed, what the monitoring methods are, what are the costs, and what is the time framework. And what is also important to understand is that this implementation must go beyond formal implementation. So it's really not about ticking the boxes and just saying, okay, we fulfill those requirements and it's done, because it must lead to specific objectives, as I mentioned at the beginning. And this is problematic because according to the Commission study on 20 years of antitrust remedies, although most commitments were formally implemented, fewer than half achieved their intended competitive effect. And here, behavioral measures were particularly cited as toothless because of absence of adequate monitoring mechanism and also because of the lengthy duration of proceedings, which undermined the impact of the whole process. In the US, and there was the study about the US situation, it's a bit more optimistic though, so maybe something to learn. The final points, these are the monitoring mechanism. Of course, very often there is a call for trustees who are particularly vital for complex technical remedies where the competition authority lacks specialized industry knowledge. And as I mentioned at the beginning, in the case of structural remedies, the underlying issue is to find an appropriate buyer. But there are also examples of joint monitoring mechanisms, so by regulatory authorities, but also competition authorities, for instance, in Korea. The time framework and the flexibility of the whole monitoring process. So it should be long enough to allow for the intended effects and to appear, but also short enough to account for the dynamic nature of the markets. And this is a very difficult factor to kind of weigh in. And their procedure should be also flexible enough. So there needs to be the presence of some sunset or review clauses that allow to review the remedies in the future, especially those of a behavioral nature. And the last question, which actually is provoked by the judgment in Croatia from December the last year. So to what extent remedies can be suspended or amended? There was a request from the company to suspend the execution of remedies posterior to the adoption and to the finalization of the decision. And this is especially interesting in the situation when the company actually agreed to those remedies. So when there was a cooperation between the authority and the company. So, but I'm sure we will hear more about interesting cases in the follow-up. Thank you.
Well, thank you for this tour de force on what it takes to make a remedy. Just to say, thanks also, I think we'll hear more about dynamic markets and timing considerations from Julia, who incidentally was the senior litigator on the AdTech case, so I think we'll hear a bit about that. Just to say, and I think you may have seen it on our webpage, you mentioned cooperation. We will have, for those of you who work in competition authorities, a workshop on remedy design focused on cooperation throughout the day until early in the afternoon tomorrow. So this was a good lead-in to what is happening tomorrow. So we know now the ingredients and what it takes to bake a remedy. But I think we said in the beginning, we all agreed that remedies only count if they have impact, so if they meet reality, as we say on our webpage. And I think you had a very short preview of Damien's slides, which if we can put them up again, it would be great. So Damien, may I turn to you and ask you, first of all, if you have any thoughts on what Małgorzata said, and if you would like to share with us views on how to, 10 golden rules on remedy design.
No, thanks very much, and thanks for the invitation. It's very good to be here and to support the OECD. Terrific work, and as a platform for us to meet in these uncertain times. Look, first a quick comment on what Małgorzata said, but mostly on this idea of starting the conversation by focusing on the principles for designing remedies and how they apply. I mean, and it's a provocative thought, you know. I mean, should remedy design really be principles-based? Because remedy design is fundamentally where one turns, findings of an investigation into, action. And, what ultimately matters, obviously, is how to restore competitive market outcomes. So remedy design, in my view, in my distorted enforcer's mind, should fundamentally be outcome-based and really seek to address, the problem. So that, I think, from my perspective at least, effectiveness should be the compass. And then you should look at whether it fits in the principles, I think, at a later stage, right? Also when you have to consider different alternatives, et cetera, et cetera. And obviously, competition authorities need to abide by the rule of law, very important, including due process, proportionality as well. Actually, due process is the best ally of competition authorities, because it's by respecting due process rules that it forces you to engage into dialogue with parties, with stakeholders, and to enrich your knowledge and your understanding of what will make the remedy effective in the future. And proportionality is important, but again, it should only apply to the choice between equally effective remedies. So the point I would just make is that let's not conceive of remedies as really icing on the cake, right? The remedies, they're very much part of the cake of whatever you were planning to cook with your ingredients. My kids would say it's the chocolate in the Marbelkuchen. So I think they're very much part of the cake, and their design should really primarily be driven by the outcome that one needs to achieve. Of course, factoring the process and institution constraints, but before considering possible limitations arising from applicable principles and the legal framework. Now, moving on.
Yes, unless, Julia, would you like to give a microphone?
Well, first of all, I do want to say thank you very much. It's such a pleasure to be here with all of you. Today has been very exciting for me personally as a practitioner in this space who just finished a 3-week remedy trial. Remedy trials don't come around often enough, and I was privileged to lead the U.S. Department of Justice in our remedy trial in the Google ad tech case, and it was fantastic. But this conference has really given me a jolt of energy all day. It's been great to be here, to hear the great ideas and the exceedingly relevant content that this group is producing is just really inspiring. So thank you for all of that. I will have some disagreement, no surprise there, with some of my fellow panelists who I greatly, highly regard, but I'll save that for a little bit later and let them continue for now.
So moving on to the practical challenges in designing remedies. Look, I think remedies and remedy design in particular have been the subject of increased attention in recent years, beyond the peculiarities of individual cases. And that's notably because of the succession of high-stake antitrust litigation in the digital sector over recent years. And so the demands of stakeholders to really, for competition authorities to strengthen their remedial practice, I think, are high. And at least in Europe, there is, on top of that, demands on competition authorities to become really enablers of large industrial projects, which means involving competition authorities really in securing outcomes by means of remedies to ensure that these large industrial projects are actually at the end in the general economic interest. So that's also a reason why they're particularly important and under the spotlight today. And that renewed attention has also reached the shores of academia. I think there is a lot of literature being produced in law and economics in recent years on remedies, remedy design, the challenges and how to overcome those. I mean, can only recommend you a wonderful paper by my fellow countryman Friso Bostun, 2023, in the Journal of Economic Law and Practice, called Antitrust Remedies from Caution to Creativity. I fully endorse, his assessment that, the challenges in designing effective remedies, they're not so much based on legal frameworks and restraints. They're very much due to real-world constraints. And these are really the real-world constraints that have historically led competition authorities to be unduly, overly, I don't know, but certainly conservative in remedy design. And so he points to a number of practical barriers, information asymmetries, resource constraints specific to digital markets, actually, and they're many. Multi-sidedness, feedback loops, which complicate design, network effect, which make restorative aims particularly hard. Conduct, which is often embedded in business models and product design, right? So that makes also remedy particularly hard. And of course, remedies which risk rapid obsolescence in these very fast-moving markets. And of course, there are also litigation risks, et cetera, et cetera. You have also a really nice overview of challenges in remedy design in the European Commission ex-post study of last year, which is really really interesting because it's really looking at a broad sample of 108 cases and really very candidly drawing lessons about what's gone wrong, and also making I think there are 18 recommendations about how to sharpen the system of remedy and the practice of remedy design at EU level. I understand that CAG has done something similar in 2020. I'm less familiar with that, but so these are really important studies from which we can learn a lot. Now, cutting things short, what I have done in preparation for this session is really take a step back from my practice as I coordinate a group of 50, 60 people who run cases, and a big chunk of my time is actually being involved in remedy discussions with parties, but also in the crafting really of these remedies. And so taking a step back, I want to share with you my 10 golden rules for remedy design. There's nothing scientific there. It's just a retour d'expérience, some feedback, and you tell me what you think about those. But just food for thought, right? And by the way, it's pretty challenging because obviously, as an exercise, because obviously, remedies, as I have already said, are and must be inherently case specific. So here it's really extracting for the sake of the exercise and trying to feed into this discussion. So I don't know if the slide is on the screen, but I think my first golden rule would be consider remedies from the get-go, even before intervening, in fact, before opening proceedings. You need to have some sort of vision for the types of measures that would be capable of remedying, the harm, if obviously your theory of harm, ends up being supported by, the evidence. Now, to be clear, I do not consider that antitrust liability should be defined by the availability and effectiveness of a judicial remedy. That has been put forward in the literature recently. That's not what I mean. I absolutely do not understand that approach. But still, I think it's very important to have, at least some sort of idea of where this case could land before you invest resources, and also before you intervene. That is, somehow you disrupt the ongoing, market interactions. And I'm not from you, but I may understand that people might think, oh, this is the ultimate enforcer's bias kind of consideration. You want to have a remedy before you even start your investigation. Not at all. Not at all. I think it's all about planning, including prioritizing, and purpose. And it helps everyone, including the parties, focus the intervention if at least you have a sense of what the solution could be, if obviously evidence supports the concerns that you have. Second golden rule: keep an open mind, is the corollary of the first one, and it's also one that counteracts this enforcement bias consideration. The vision of what an effective remedy can be, including whether it is at all necessary at the end, will and must evolve as the investigation progresses and as the information asymmetry gap narrows. I think that's absolutely vital. By the way, keeping an open mind also means keeping an open mind towards, principles which exist for a good reason, because very often they're anchored into empirical findings as to the desirability of structural over behavioral remedies, or the particular concern about monitoring intensity, etc. Those are very relevant considerations, but you need also to be able to extract from these principles to make your intervention fit to the case and to the issues you want to deal with. Third golden rule: embed the remedy in market and deal dynamics. Obviously, this is a matter of both outcome and implementation effectiveness. You need to embed your remedy into market dynamics to ensure that the outcome of the remedy will be effective. That means you need to factor into the user's requirements, the procurement strategies, obviously what the market needs in order to design an effective remedy. And then to achieve effective implementation, you need to be fully aware of the incentives of the parties to an M&A transaction or a cooperation agreement, or the incentives also of a dominant player, so that you can make sure that your remedy design process also fits into the incentives of the parties, so that you can try to secure a swift outcome that is also effective. Fourth one: give early signal of a need for or openness to remedies. And that's a timing issue that Julia will probably also deal with later on. But I think the earlier the better. After, of course, a sound preliminary assessment of the evidence that confirms the theory of harm, it's definitely worthwhile in everyone's interest to signal an openness of a potential need for a remedy, because the incentive to settle for remedies can be higher at an early stage in a procedure, since what the parties can secure is early termination of the proceedings or swift clearance of a transaction. And so there are obvious benefits for companies, but also for enforcers, because it may maximize the chances of reaching an effective outcome, and also because the margin of appreciation may then be higher, right? Because you're not at the end, you're not at the stage of a finding of infringement, but you're earlier on. It's about very often to then negotiate, commitments or a settlement, and that gives more flexibility and more leeway to the authorities. Fifth golden rule, I'm going to accelerate because I'm getting a bit long here, but obviously you need to be creative and think outside the box. And I think it's very good to start from a blank page. You sketch your ideal remedy to the harm, do some blue sky thinking, and then you come up with a concept or alternative concepts obviously then you need to integrate the learning outcomes of your assessment process, of your investigation, and then add conditions and obligation to maximize effectiveness and successful implementation. And that's an exercise that's extremely useful also in a commitment situation, for example, because then you know where you could land in terms of outcome of the interaction with the parties, and also you avoid capture, right? Because you have your own vision of what you should achieve. The sixth rule, obviously, invest resources, sufficient resources, and make sure that experienced individuals are involved in the remedy design process, because it's very complex and experience is really required, to be effective. But then everybody needs to be involved, because your remedy needs to be anchored in the findings of your case. So you need your expert, your case team, to be also involved. And this may have also institutional consequences. I mean, there is a debate that's alive, and for good reasons, as to whether you should leave remedy responsibilities with the case team, or have special units focusing on remedy design or implementation. I mean, my own view is that design should rather stay with the case team with the assistance of experienced people, and then implementation can be indeed outsourced or in the hands or the primary responsibility of a dedicated team. But that's if, of course, you have a sufficiently large organization that can sustain that type of arrangement. 7, go step by step and explain. That is also, be transparent. I think you need to go step by step, because the companies, the parties to a case, also they need to process what you come up with and what they might actually have to change in terms of business practices, or and so I think very importantly is first to secure a remedy concept with the parties, and then go layer by layer, adding conditions, obligations, and in the most transparent way possible, explaining why you need this or you need that, because that can only facilitate the process. And then you do the sanity check of proportionality, but be sure that the parties will do it for you. 8, test and stress test. I think testing remedies is essential. It should be systematic in all cases. I mean, in Belgium, it's mandated by law. And so it's a matter of remedy design and trying to bridge, information gap. And actually, what's interesting is, that you can do some testing with stakeholders, but you can increasingly do, self-testing or self-stress testing, in the sense that by working with economists, our experience at the BCA is that you can run probabilities, right, and do your own internal probability study to see what is the very likely outcome of the remedy that you have actually designed, or the concept that you have. It's quite remarkable what nowadays one can do with data analytics in that respect. 9, seek support, seek partner support. Again, tap into the expertise of actually industry experts, of sector regulators, not only because of the expertise on the substance of the function of market dynamics, etc., but also the expertise into what works and what doesn't when it comes to remedy. I mean, I have a case in mind where, when I worked at the European Commission, we hired an expert during a merger control process, and the expert issued a report saying, what, the remedy that the parties are proposing cannot work, because the shipyard that they want to use is not deep enough, and so the ships they want to build into it, they're going to stand on the ground, and they're not going to be able to move during the shipbuilding process, which means you will need to run the ship into high sea, turn it, take it back, which is going to take ages and is going to be totally inefficient. That was the end of the story. So, expertise is super important, and not only in the design phase, but in the implementation phase. Selection of your monitoring trustee is really, really important. And make sure you partner with a very good monitoring trustee, that the mandate is clear. Be demanding with the monitoring trustee. Make sure that he reports or she reports on what matters in your case. Challenge the findings. So this is super important. And finally, it's very important to make remedies future-proof. So not only to prevent repetition or future distortion of competition, but also simply because market evolve, and you need to build into your remedies the at least potential evolution in the market conditions, right? So you really need to adopt a dynamic approach. Increasingly, what we try to do is to really build into the remedies safeguards, or even a full plan B in case the remedies need to be adjusted. Imagine, pure speculation, anchor in reality, long-term behavioral commitments. Obviously, they're subject to market evolutions, etc. Well, why not? And we're trying to do this these days. Having a clear alternative plan B built into the commitments or the remedies that says, in this particular case, well, you will have to actually divest a particular asset. And I think these are the kind of things that we should increasingly take into account. Likewise, add anti-circumvention clauses into remedies, because that can only facilitate and lower the threshold for intervention in case of failure to abide by the remedies. These are things that actually can make a difference and secure effective outcomes. So that's it. So this was a very impressionistic overview, but I hope it resonated to some extent with you, and happy to hear your reactions.
Well, thank you. That was, yes, impressive and also very easy to retain, and we might copy your fantastic 10 golden rules. It also preempts a little bit and goes very well into the rest of the conversation. Before we go into timing issues, things that we've discussed, the whole panel, with Julia in particular, I would like to ask you both, Gozia and Julia, if you have any views on what Damien just said before we approach the specific issue of timing in remedies.
Just maybe very briefly, I don't think that we are so far, actually, in perception. So while zooming in, I also think that what you showed in your, even if these are effective remedy design golden rules, there are proportionality and the fair trial safeguards included, so they kind of implicitly they are there, but that's not the case for all the authorities. So if we talked from the design perspective, I would still stick to my balance of principles.
So first let me say, because I'm required to say it and it's also true, that the views I'm going to express today are my own, the experiences of a trial lawyer for 25 years plus, but they are not the views of the U.S. Department of Justice, and obviously the Department of Justice may view things very differently than I do, or take different actions that I might contemplate in a given case. But in terms of where I weigh in on this particular issue, one of the wonderful opening remarks from our Nobel Prize professor really brought it home, because one of the things that is most challenging when designing an effective remedy is how do you deal with the revolutions that happen. And we're going to talk about this a little bit more when we talk about timing and some of the practical realities of the timing of a remedies phase of a proceeding. But one of the things that meant to me is, what do? How do you future-proof? And I think one of the ways you future-proof is by abstraction. And so that does require you on some level to boil things down to basic principles. So I actually agree with both of you. I think you do need, and I'm not just doing that because I find them to be very nice people, but I do. I'm also saying it because in order to future-proof something that is very concrete and very case-specific, You have to have general broad principles. And in the United States, we are obviously a precedent-based system. And so for nearly 100 years, the United States Supreme Court has articulated some fundamental principles that we apply to everything. So the principle very much consistent with the OECD guidelines, which include you need to make sure you terminate the monopoly if a monopoly has been found. You need to make sure that you deny the defendant the fruits of that monopoly, that they're not allowed to retain some of the benefits that they obtained illegally. You also need to make sure, of course, that you unfetter the market from those anti-competitive forces and that you restore competition. And you also need to future-proof by making sure that the defendant is not permitted to engage in future practices that are likely to lead to the same place. Those are principles, and they are what I would maintain allows us to address any revolution that comes along. Because while AI is the revolution we're all talking about now, and the internet was the revolution everyone was talking about in the 90s, these principles are consistent. And so, yes, it requires both abstraction and concrete application. So I think that provides us harmony for the cocktail hour, I hope.
I love this. So this is a wonderful wrap-up. I don't even do it. So just as foretold, I think we mentioned timing several times already. And we know, because remedies are inherently future-looking, that timing counts. So when we say timing, it's not just the time that it takes for the measures to be implemented, and that should be computed in, but the time it takes for the results of the measures to bring about the desired effect, which is another timing, but which also counts. We've already mentioned, and I think we can invite Julia to let us know more about dynamic markets, and especially digital markets, where things evolve very fast. They evolve while the investigation is taking place, and they will evolve in the future. Gozia mentioned tipping risks. Damien mentioned some of their characteristics, so we know that timing matters. Future-proofing, abstraction or not, impressionism or not, matters. So Julia, would you like to take us through some of the timing considerations?
Well, I think, again, timing is a necessary complication and byproduct of the principles we've talked about, right? So many of us here are practicing lawyers, and we believe fervently in the value of due process and a fair trial. Well, what does that require as a practical matter for we litigators? That means a thorough investigation before you bring a case. You don't bring a case without appropriate foundation. Guess what it takes to bring a case with appropriate foundation? It takes time. Once you've brought the case, bringing it is not enough, because your say-so is not what matters. It's what matters, what you can prove in that court of law, at least in the United States, or before whatever authority you're appealing to. But guess what? Presenting that evidence to the finder of fact takes what? Time. So we have time not just from the decision of when you decide what remedy you want to implement, but time years often before that. You know, the Google Ad Tech case was deliberately brought in a jurisdiction known in the United States as the Rocket Docket, because it was known to move cases very, very quickly. We filed the Google Ad Tech case in January of 2023. It is now 2026, and we're awaiting a remedies decision from the court, and that is record time in the United States. That required unbelievable resources and in great intensity from the court and from the participants, but that is still nearly 3.5 years in a digital marketplace. 3.5 years ago was the Paleozoic era of dinosaurs, right? Things are moving so fast, and so that is why I think you have to be flexible and nimble, and you do have to look around the corners in the future, because time is of the essence, but yet you can't rush justice. You have to give the defendant their fair day in court. You have to comply with the legal niceties and the appropriate due process. But at the very same time, if you implement a remedy that solves yesterday's problem, you have won the battle and lost the war. So it does require great humility, but also great creative thinking from competition enforcers, so that you're not just thinking about yesterday's problems, but you are thinking about tomorrow's problems, and that you're designing a remedy that goes to the heart of the matter. And what I would argue, and what I believe the case law in the United States supports, is you have to look to the defendant's ability and incentives. Ability and incentives. If the defendant retains the ability to commit anti-competitive acts in the future, and that ability is coupled with an incentive to do so, you must apply your practical, logical sense to anticipate that the defendant will continue to do that, and your remedy needs to take that into account. We talk about the passage of time. I'm just going to share with you one of my favorite quotes from a United States Supreme Court case, International Salt. This case is from 1947, and I think it applies equally to today. The district court is not obliged to assume, contrary to common experience, that a violator of the antitrust laws will relinquish the fruits of his violation more completely than the court requires him to do. So don't anticipate that the defendant is going to be chastened necessarily by a liability ruling and will give up things that your remedy does not require the defendant to give up. And then the court goes on, it is not necessary that all of the untraveled roads to an anti-competitive end be left open, and only the worn one, the road that was traveled the one time that the defendant got caught, be closed. And so that is a visual that we use throughout the ad tech trial. We literally put a large screen, because I like graphics, and we had a massive monopoly castle up and showed all the potential roads to that monopoly. And yes, your remedy can foreclose the one route that they took before. And if all your remedy does is prevent the defendant from doing the thing they did to get to the monopoly, you will have lost the battle and lost the war, because there are multiple other roads to get to the same place. So again, I think timing is of the essence, and we have to be able to think forward, but that is something we do occasionally in the law. In merger cases, obviously, we're thinking about future. We do put on evidence. In the ad tech case, we had, as I said, weeks of evidence from market participants who are very steeped in the details. They know exactly how deep the channel is and whether the boats can come in and go out. And you put on that evidence and you show what is likely to occur in the future. What are the incentives and what are the ability of the monopolists, and design an effective creative remedy that can prevent that future monopoly.
Thank you very much. Just to say, I love how all this comes together. We hadn't discussed to this detail, and we didn't have the slides, but clearly what everyone has said, Damien, is also linked to the slide. So this slide, because Julia just discussed resource intensity, then due process that Kozak had said, then engaging with the parties, future-proofing, etc. I'll turn to the other panelists, with thanks to Julia, to share your thoughts on what you've just heard.
Well, look, I mean, it's hard to disagree with what Julia said. I think that's that's very central to any process of designing effective remedies. Essentially, something you did not touch upon, Julia. I mean, maybe you can share also what your experience has been in the US as a litigator in the past, is how impactful interim measures or interim, I don't know exactly how you call them in the US, but interim remedies can be providing temporary relief, or because obviously that then you are. Or you can be at the very beginning of your case, and it can be a very effective way to directly impact market outcomes. And actually, in Belgium we have a lot of experience with interim proceedings. I think in France they do as well. In other jurisdictions, less so at EU level historically, but the Commission has somehow rediscovered that recently and is increasingly using the possibility to impose interim measures. And so that allows for securing temporary relief, but also what it does, and something that's actually more important, is that it completely changes the incentives and the dynamics of the overall case. Because what happens in these interim proceedings is that within a very short period of time, suddenly you're able to move into building your case at a speed that you can never achieve in normal circumstances, because you need to actually test your theory of harm directly before a panel or a judge. And also the parties have to reply to your argument and disclose then all kinds of facts and figures in order to do so. And so you win a tremendous amount of time. If you're successful, the incentives completely change, the whole case dynamics change, and you may actually secure remedies very quickly, also not only temporary, but final remedies very quickly by means of commitments or otherwise. So our experience has been that within 3-4 months of accelerated primary primary investigation, you can then test your theory of harm, and then have the parties and yourself really focus on a solution instead of then getting lost for months or years into discussing legal or economic nuances, which can actually be factored then into your remedy discussion, because they're not irrelevant. They're actually very relevant. But when you factor those into your remedy discussion, you can cut short the whole process and be much more impactful. So that's really something that I just wanted to put on the table.
I think it's a wonderful idea, and it does exist in principle in the United States. The challenge is, again, we come up with these competing aspects of the paradox, which is due process. And so obviously, if the defendant is not in agreement about what those remedies might be, and you're talking about asking a court to impose interim remedies before a final judgment, the standard to get that interim remedy is quite high in the United States. You have to show a likelihood of success on the merits. You have to show that the remedy is necessary and there isn't some other recompense that could be provided later to serve the same purpose. So there is a sort of built-in bias against an interim remedy, I think, in some ways under United States law. But I agree with you that having that engagement early, and to the extent you can get any cooperation with the putative defendant, either during the investigation or after the case is filed, is always worth time well spent. Because obviously that time you can put in on the front end, you can get a remedy much faster than it'll ever take by litigation.
I mean, I have two short points or more impressions while listening to those both very interesting experience-based interventions. So first of all, I think we need also to discuss that we need agile and resourceful authorities, because with the amount of evidence, especially in digital investigations, we are not any longer talking about data rooms. So these are really giga rooms of data. So that's the first thing. And the second one is that interim measures, this is a deliberate choice of some authorities not to open, or not to use those instruments. I'm thinking you mentioned the Commission. So the practice of the Commission was not so constant, I would say, with interim measures. which maybe is a pity because this is an instrument that could have been much more useful in respect to digital market. And it also shows that the authority needs to take a risk sometimes and not to be afraid of what will happen in the court.
Can I just add one thing that had just occurred to me on that front? It also depends on the type of remedy that you're contemplating, because obviously to the extent it is your estimation, and I totally agree, you need to think about potential remedies from the get-go. If it is your estimation that nothing short of a structural remedy will suffice to solve the problem, that's a very difficult interim remedy to impose. And at least in an involuntary setting, that is the type of remedy that a U.S. judge would be very reluctant to order on an interim basis, because it's very hard to unscramble the egg once you've already divested the company to put it back together again. I think most judges would be afraid of that and would prefer to defer the decision down the road. But I do think, that early engagement and thinking about your remedies from the outset, and to the extent your case is not one that requires a structural remedy, even though that is often, I'll just put a plug in for structural remedies, the most effective and the cleanest and the surest remedy. If it's a case that involves a structural remedy, I think that can make an interim remedy even harder to secure, at least under US law.
Yeah, I understand. I mean, you need to think about the specificities of each case. I mean, there might be cases where it might make sense to secure on an interim basis more behavioral types remedies, and then realize that, in fact, they do not work, and you can actually then show the judge, you see, they don't work. And so you need to go for a structural solution. So it really depends on the dynamics of each case, I believe. And also you need to pick the right cases to actually seek interim measures. But the more I grow into my current role, the more I think that we could try to envisage this in a more systematic way, in unilateral practices cases, notably, and then also be flexible in going back to the court or to the panel, saying, okay, well, maybe there is no need anymore for these remedies, or but having at least a dialogue with the parties at an early stage about what the concerns are, obviously, but also what should be done quickly to try to keep the market competitive.
I mean, that's very interesting, and I would have some follow-up questions for you, but I'm mindful of the time, and I would like to see if there are questions in the room or on the chat. We have a chat with written questions. If yes, a microphone there, please.
Thank you for the presentation. Christophe Gardi from Digital Competition. I have a question about the impact of remedies. Because when you adopt remedies, the incentive of the company change and the structure of the market change. I would take two examples. The first one is about rebate. When you have a remedy saying like rebate is not anymore legally possible, the firm what will do, they will simply stop rebate. But the consequence is that it will increase price for the company that were before benefiting from the rebate. Another example is when you change the incentive of a company to move from a free licensing through, because it did attain practice. Here I'm referring to Google, Android, for example, and then he changed, and now he's licensing the practice against the price. So it's increased at the end of the day the price for the operators. And so the question is, okay, this is a remedy. I understand the way to resolve the antitrust issue, but the impact for the market is actually negative. So how do you deal with that actually?
I have one thought on that. I was listening to the last panel with Professor Tucker, and I thought it was interesting, her comment, you always have a P, right? You always have a P in the equation. What's the price harm? What's the price harm? And we've been brought up and indoctrinated in a system where we really give tremendous focus and attention to price-related harms, but they're not the only related harm. And I would argue that in the society we're in now and in the economy we're in now, the relevant currency may be less monetary, and it may be something like data. It may be something like people's attention. A lot of products and services are being offered, quote unquote, for free, but there's a reason they're offered for free. It's not pure altruism. It may involve some altruism, and it certainly may involve altruism at the outset. But ultimately, when profit-making companies provide something for free, there's a reason for it. And the data that they're getting, or the attention that they're getting, and the advertising they're able to provide, or whatever, is the equivalent. And so that is another part of how we need to follow Professor Algon's admonition to keep up with the revolution. Don't find ourselves overly beholden to old ways of thinking that price is the only or the primary form of consumer harm, because I think there can be other types of harm. And certainly in any remedy, we need to look at countervailing harms in the marketplace. But we need to be careful about how we think about harms and how we think about benefits, and make sure we're capturing all of the harms and all of the benefits, and not just the ones that used to be relevant in the old world order.
I mean, just maybe one comment. Obviously, you have to try to control for the possible consequences and what the incentives of parties will be. Once they start implementing your remedy. Now, you cannot always control for everything. Obviously, you should try to make your remedy future-proof, as I said, and provide for ways to reopen some discussions at a later stage if things turn sour. But this was the my point on saying that remedy design needs to be really anchored into market dynamics and match the incentives of the companies, is precisely to avoid these, as much as possible, these sort of side effects. Now, there can be trade-offs between price-related and non-price-related benefits arising from a remedy. I think Julia put it very eloquently. But to a large extent, these are things that you need to be aware of and try to control for, and if needs be, being able to revisit certain issues then down the road.
I mean, we can take more questions from the floor, but I'd like to check. Are there any questions on the chat? Yes, we have. Okay, then can we get some questions from the chat?
So we have one question from Ekaterina Komutinikova, I hope I pronounced it correctly, who asks, what safeguards, in your experience, have worked best to keep temporary crisis measures temporary? So sunset clauses, review triggers, transparency requirements. So which of these measures have worked best, in your opinion, in your experience in university or in managing cases?
Who would like to go first? We can take them in order, like Julia, then Gozia, then.
So, in the Google Ad Tech case, we thought it was very important to propose both what we called interim, but they were still post-liability verdict. But they would be before a structural remedy of a divestiture could take place. Again, you have to always deal with the practical reality of time, and it does take time to divest a company. And so we are seeking a divestiture, but in the process, while that process is playing out, we did seek certain interim measures. And they sort of work as a belt and a suspenders. You need both, and they complement each other in very important ways. And so I think there can be any number, and it really is not capable, in my experience, to generalizing. It really does depend on the unique circumstances. For example, we proposed with respect to one of the monopolies, which was the monopoly over the publisher ad server, that there be a contingent divestiture, again, to see how the facts played out. And so we proposed an interim divestiture that was effectively requiring the defendant to make the product open source and available to all. And only if that did not solve the issue would there then be a later full divestiture. But there are also plenty of behavioral remedies. But I think, you know, again, the sky's the limit. You need to have some level of creativity and again, talk to your industry participants, talk to your experts to see what is the behavioral or interim relief that will do the most for the least amount of effort. One thing you always need to think about with behavioral remedies is, you know, there's a tendency to think that structural remedies are more burdensome. But there is an element of burden to a behavioral remedy in the monitors that have to be employed to monitor the behavioral remedy, in the work that the enforcer has to do over often many, many years to continue to have that case open and make sure the behavioral remedies are being complied with, for the court to supervise the remedies. So again, something to weigh when you're considering all these factors is the burden of the behavioral remedy on all the participants, not just the defendant.
I think that our discussion previously showed that there is no universal recipe, that it's always case-by-case analysis. And I also want, or while referring to a previous question, what is extremely important for the authorities to understand the incentives for the wrongdoing, because this is the source really of all the actions. So if the authority knows the market well or is able to talk with stakeholders on the market and identify what is really going on and why it is going on, then it's easier, of course, or easier. It's then the whole process, as explained by Damien, is kind of is possible to carry through.
Look, yeah, not much to add, except to say that it's fundamental to, you know, make sure you can come back and reopen certain issues and get back into the game, to secure a future role for the authority in, you know, the implementation of the remedies, in particular if they are, you know, very long-term remedies. And so, but that can take many, many different forms. Yeah, so it's hard to discuss all potential or all possibilities. I think there are classic situations where at least, you know, you secure your involvement in, you know, approving a purchaser, you know, but you can also secure, you know, a notification of an acquisition that would follow, for example, the you know, a pre-existing supply relationship, and make sure then that you can reassess the impact of that acquisition, even though it's below the merger control threshold. That's something we've done recently. And as I said, we can currently in discussions with the companies to contemplate that, you know, if they fail or if they have to discontinue for economic reasons, continuing to offer certain services, that then they will have to subject themselves to a divestiture remedy. And so these are all kinds of things that you can build, that you can craft into your remedies, and that you should really think up front, obviously. And yeah, that's pretty key in ensuring, you know, the future-proofing of the solution you've designed.
Well, thank you very much. We may have time for one short question from the floor, or we can close exactly on time. Just to say, this was very enlightening for me. I encourage you also to read the OECD research around the matter. What struck me is not only competition related. There was quite a lot of discussion around cooking and art, and the interface of competition law and policy with ingredients and baking, as well as with abstraction, impressionism, and the naturalistic depiction of paths that lead to monopoly. For me, and my own assessment is that art wins and cooking loses. We heard there is no universal recipe, so don't try to do it. But clearly, competition and art, there is the topic of a PhD right there. There are ways that you can depict competition enforcement, and apparently there are elements in all. Thank you very, very much. Thank you to the panel. Thanks for making it all the way from the US, from Warsaw, from Brussels. Thank you, Damien, for staying tomorrow with us. Thanks to all of you. It has been a very long day. Thank you.
And thanks to the OECD, which is really doing a terrific job, I think, to serve all of us, in fact. So it's a great platform. It's great that you can showcase what you do in a day like this. So thanks for the invitation, and hopefully there'll be many more of these in the future.